What kind of challenge to notice can a property owner make when fighting a default judgment for foreclosure? To find out, you have to read Nutter versus Saratoga, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on Nutter versus Saratoga. This can be found at 2023 New York Slip Opinion 01469, published by the Court of Appeals on March 21st, 2023. This is a civil case. It's a tax case. The issue in this case is what kind of challenge can a property owner give with respect to notice of a tax foreclosure proceeding. I'll get into all that in a second. What you have to understand this case is that RPTL, which is Real Property Tax Law, Section 1125 1B, RPTL 1125, talks about the notice that has to be given to interested parties of a tax foreclosure, okay? So that any interested party, meaning the owner of property, has to be given notice, and that notice is defined in RPTL 1125 as first-class mail and certified mail. What has to be mailed is the petition, the notice of proceeding, the notice of foreclosure, all the documents. And the important part of that statute is that when they're mailed by the petitioner, by the county, they are deemed received by the property owner, by the interested party, unless they're both returned within 45 days by the United States Postal Service. So unless the USPS returns them within 45 days, they are deemed received. The second thing you have to understand is in that same section, RPTL 1125, subsection 3B says that the failure of the intended recipient to receive the notice, so failure to get actual notice, shall not invalidate the tax or prevent enforcement, which means foreclosure. So what happened here? In May of 2018, Saratoga County had a $9,000 lien on a property, and they decided to start an in rem tax foreclosure proceeding. In rem meaning that it's against the property, not against an individual. The action is actually against the property for failing to pay its taxes. So they have to provide notice to all the interested parties, and they mail it out via certified mail and first-class mail. That's good. That's what we just heard. And they send out the right documents, the petition, the notice of foreclosure, and the notice of proceeding to the plaintiff's last known address in the mortgage. That's fine. And it's not returned within 45 days. Nothing's returned within 45 days. Okay. So it's now been deemed received. So the county initiates foreclosure. They get a default judgment against the property in their favor. Now they get a deed that conveys the property back to the county. They then, in May of that year, sell that property at an auction to a third party for $140,000 or so, and that party then resells it. Okay, but the plaintiff, the original property owner, says we never got that notice. We never got notice that of the proceeding, and so they file a case to vacate. What the case we have in front of us is an action to vacate the default judgment, to vacate the foreclosure, even though some person who has no idea what's going on owns the property now. And they allege in their case that there was a failure to properly give notice. They say that they never received it. They say the vice president of the company says, well, I went down that same year to ask what taxes were owed, and I paid those taxes. They never told me that there was additional liens, and that's what ultimately got foreclosed upon, which itself violates RPTL 1112. And in response to this action, the county files a motion for summary judgment saying we should win without a trial. And they put in their evidence, the proof that they sent it certified mail, and the proof that they sent it first-class mail, and the proof that they never got anything back. And the plaintiffs here say, look at what they sent. It's not postmarked. That's a defect. Look at what they sent. The tracking information shows it went to a P.O. box that doesn't belong to us. So this really was defective service. They never got actual notice, they say. But the Supreme Court, when they review this, they say, we're handcuffed by the statute. It says it's deemed received if it's sent out and not returned. And there's no question here it was sent out and not returned. So they grant the summary judgment motion in favor of the county, as does the appellate division. It goes to the Court of Appeals, and they say, that's not right, because tax proceedings are supposed to be liberally construed in favor of the property owner. It's supposed to be getting taxes, not forfeiting property. And they say that, yes, it's true that if they certify mail it and they first class mail it and it's not returned, it's deemed received. But that does not mean that the courts are foreclosed from looking at other proof. And the plaintiff here brought other proof. And the Court of Appeals is not saying the proof is sufficient, but they're saying that the trial judge was wrong, the appellate division was wrong to not even open their eyes to what that proof was as to whether it was sufficient, because they had both read that statute as not allowing any other inquiry into whether it was sufficient notice aside from the 45 days return issue. So the Court of Appeals says that other proof can be looked at and relevant, and that's the case of Nutter versus Saratoga. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.